allow me to address the court, please.
This is who?
David Omolama.
Can we finish with the respondents first before we come to the interested parties? Let's finish with the principal parties first.
Yes, on behalf of the third and fourth respondents. My name is Murugara, and I do apply for a copy of your ruling to be supplied as a matter of urgency, and also the proceedings, if they can be typed with the same speed. As the third and fourth respondents are aggrieved by your decision and wish to move to the Court of Appeal for a stay of those orders pending appeal. In the meantime, and on their behalf, I do apply for a temporary stay for 7 days as the effect of your orders against the fourth respondent, being the National Assembly, together with the Senate, being the House of Parliament, are grave.
How?
Grave. This is the second arm of government.
This is the what?
The second arm of government.
Okay.
And on behalf of the second arm of government, which argument also extends to the third arm of government, the judiciary, there is going to be a constitutional crisis. Crisis because the first arm of government will not be able to collect or appropriate revenue to itself and the other two arms of government. What comes to mind immediately is the effect of the order the court has just made. We must take cognizance of the fact that the Finance Act we have today amended in some respects and repealed other sections of the Finance Act 2022 and the relevant statutes thereunder. So we ask ourselves, for those sections that were repealed, where do they stand as far as revenue collection is concerned? And as far as the ones that were amended, that amendment stands suspended.
That amendment? Sorry, Honorable Murugara, unmute yourself.
Thank you. Thank you very much.
Sorry, please state what you stated last.
It is that the repealed sections,
yes,
are inoperational.
Yes.
And the government cannot fall back on those sections to collect revenue. Thus, no revenue is going to be collected. As regards the amended ones, the amended sections,
Yes.
those are inoperational because the amendments have been suspended. The government therefore finds itself in a limbo as far as collection of revenue is concerned. But most important is what happens in the interim period to the three arms of government. No collection of revenues and no appropriation of any revenues that may be available. Thus, being not aware how long it will take to have the matter determined by the High Court before the bench of 3 judges, the only reasonable and prudent thing for us to ask the court to do is to exercise its secondary jurisdiction in matters such as this, to suspend or to stay the operation of the order for a given period of time as the parties seek recourse in the Court of Appeal. I therefore urge you, my lady, to consider the application for stay favorably. Thank you.
Thank you, Honorable Murugara. Next, for the respondents.
Your Ladyship, this is Otiende Amolo.
Yes.
I do not know if you'll allow me to go first, then perhaps Senator Kia could join shortly thereafter. I'll be very brief.
Just a minute, Honorable Amolo. I'm just wondering if we've covered all the respondents, and also can we hear the interested party who supports the respondents before you then respond?
Very well. All the respondents have been heard.
All right, so let's have Mr. Omulama who supports their case, and then you can respond.
Very well.
Omulama?
Thank you, Your Lordship.
Yes.
My name is Omulama for the 4th interested party appearing in person. I would wish to associate myself with the sentiments and submissions of Kanzo Kiragu Kimani, Kanzo Mahat Somani, and also Kanzo representing the Senate. Your Lordship, I want to remind the court that last time we were before you, you asked a question as to whether we have any legal framework by which government can revert to the Finance Act 2022 in the event that the current Finance Act is suspended. Your Lordship, you did not get an answer to that question. And Council representing the Senate has espoused very well that there are sections of the previous Finance Act which were repealed by the current Finance Act 2023, and others were amended, and therefore they cannot be reverted to without a legal framework. I therefore humbly pray that you heed to the respondents' plea to have your ruling suspended for 7 days, pending the intended.
Mr. Omulama, I can't keep up with you. The provisions that were repealed or suspended, and therefore?
Your Lordship, you have to appraise me where you didn't get me.
Yes, that there are provisions that were repealed and suspended.
Yes. There are provisions in the Finance Act 2022 which were repealed, and others were amended, as explained by Council for the Senate. Therefore, we are humbly praying that you do heed to the plea of the respondents to have your ruling suspended, because to us, the prejudice that the respondents will suffer and the state of affairs that the country will find itself in is more grievous, is more serious, and is a bigger prejudice which plays against public interest than the suspension of your ruling would actually occasion to the petitioners. 7 days is not too much to ask. I believe the respondents will move with speed to have the matter articulated again before the Court of Appeal for us to get finality, because government cannot spend, and we believe so, without provisions of the law. And there's no clear provision that has been put before you by which government can revert to the 2022 Finance Act in respect of the repealed sections and the amended sections. I humbly submit.
Thank you. So,
My lady, before the Malayan friends for this petitioner,
yes,
for the petitioners can respond,
yes.
there's Mr. Mohoro for the Commissioner General, and
Yes.
myself and Ms. Tanji for the first and second interested parties. If we could kindly be allowed just to address you shortly, and then the petitioners then could respond.
Mr. Issa,
Okay.
Can we have one joint response for your client?
No, I'm saying Mohoro is for the, that's for the Commissioner General.
I get that,
Yes.
but
And
for
for
your
me, I'll
client,
address you. For the Senate, I'll address you, yes.
thank you.
So maybe the first interested party can go, and then I'll then make submissions, and we close on behalf of the interested parties.
Thank you.
Yes, my lady, mine will be to support the oral application by the respondents. They have clearly demonstrated the effect of those orders. It will be in the interest of justice that the orders are stayed pending filing and hearing of application at the appellate court. Thank you.
Malady, on behalf of the Senate,
Hold on. Yes, Mr. Issa?
Malady, on behalf of the Senate,
Yes.
we join our colleagues on behalf of the National Assembly and the Attorney General in requesting that you suspend the order of conservatory orders that you have made today in your ruling for a temporary period, Malady, not less than 7 days, and preferably for a period of 14 days, to allow the respondents move the Court of Appeal for appropriate orders. Malady, in doing so, Malady, you would be following in the footsteps of your brothers, Justice Jaira Singa, Justice Anthony Ndung.
Yes.
The High Court has similarly, in a previous petition where the Finance Act and the revenue collecting statutes had been challenged before you.
Sorry, say that again. The High Court?
In the High Court, in petition number 284 of 2019 and High Court petition number 353 of 2019 that were consolidated, had also presided over a petition similar to the one before you, where the Finance Act and several statutes had been challenged by the petitioners. And Malady, when the High Court delivered its judgment on the 29th of October 2020, the High Court suspended the declaration of invalidity for a period of 9 months to allow
Delivered judgment on which date?
29th of October 2020.
Yes.
And that was a final judgment. But Malady, the High Court suspended the declaration of invalidity for a period of 9 months to allow the National Assembly first challenge that decision in the Court of Appeal, and also to give it time to regularize the issues that the High Court had made a finding on in its judgment. Melody, just for purposes of complete disclosure, that petition had been filed, one of the petitions had been filed by the Senate of Kenya. And Melody, in suspending the declaration of invalidity, the High Court allowed those statutes to be enforced pending the filing of an appeal to the Court of Appeal. When the appeal was argued before the Court of Appeal, the Court of Appeal reversed the unanimous judgment of the High Court, which had declared those statutes invalid for want of constitutional validity. This judgment was delivered by the Court of Appeal after hearing all the parties. And Malady, what I am beseeching you is that by the High Court suspending its decision for a period of 9 months, it allowed the national government to continue enforcing the statutes and collecting revenue as the judgment of the High Court was being challenged in the Court of Appeal in the exercise of the right of appeal. And lastly, my lady, even when the matter was pending before the Court of Appeal, when the appeal was argued, the 9-month period that had been granted by the High Court was coming to an end. And on the 27th day of July, 2021, your sisters, the Honorable Lady Justice Murgo, the Honorable Lady Justice Nyamoya, and the Honorable Lady Justice Lesit extended the orders to the effect that the impugned acts specified in the judgment of the High Court will remain in force pending the determination by the Court of Appeal. So, my lady, what we are asking you to do is what the High Court and the Court of Appeal has done before. And my lady, we respect the decision you have made, but bearing in mind that there's a possibility that the Court of Appeal would reverse you on appeal, or even the High Court, when it hears all the petitions that are before you, could make a finding that these statutes are all, the Finance Act and the amendments that have been proposed are all constitutional. My lady, we ask you to exercise the constitutional power that you have and the discretion conferred on you by law to grant a temporary order of stay to allow all the parties aggrieved to move the Court of Appeal for appropriate orders. My lady, that will not invalidate the decision you have made today. It will only keep it suspended for the period that the parties will be able to move the Court of Appeal. And my lady, that will be a balancing act. And my lady, finally, as you make that order for a temporary stay, for the period that my lady you would be minded to give, my lady, it will be asking that you make a clarification that pending the determination by the Court of Appeal, the Finance Act continues to be enforced the way the Court of Appeal made, so that there can be no ambiguity and we are not bombarded by applications alleging any contempt by any of the parties. My lady, this is a matter where the interest of both the petitioners, the public interest, and the interest of the government will be balanced by you granting a conservatory order. My lady, we urge you to consider.
You asked that I clarify what? My connection is going on and off.
Sorry.
Please repeat.
My lady,
you asked that I clarify what?
my lady, that in granting the stay of the suspension of the conservatory order,
Yes.
whichever word, my lady, you would, the High Court would prefer to use,
Yes.
is that for that period that you'll grant that suspension, that the Finance Act would continue because of the presumption of constitutional validity to remain in force, because, my lady, it is a conservatory order that you've granted in your ruling. And so that there can be no allegation that any party is in contempt of the court order or the ruling that you have given today, that clarification, my lady, would be critical because it's the way in which the Court of Appeal clarified its orders, and that allowed for the smooth passage of the arguments before the Court of Appeal, and a proper judgment was delivered with both parties aware of what orders had been made by the Court of Appeal. So, my lady, we are urging you that in the interests of the public and the petitioners, as well as the government, that you grant a limited period of between 7 and 14 days, suspending your order, and that will also give time for the Chief Justice to empanel the bench as you've ordered today. Because any further orders will now, my lady, once you've made your orders today, now this will now move to the bench to be empaneled until and unless the Court of Appeal suspends the order, or that's different on the conservatory order. So, my lady, we urge you to allow, to consider and allow that application for a limited period of 7 to 14 days to allow all the parties who are aggrieved to move the Court of Appeal for appropriate orders. That's all, my lady, on behalf of the Senate.
Thank you. Thank you very much.
Thank you, Your Ladyship. Your Ladyship, we have just spent 1 hour, 10 minutes on submissions by my learned colleagues on what, with tremendous respect, is a preposterous venture. Your Ladyship, in my 3 or so decades of practice, I have never seen this. Your Ladyship, you are being asked to negate your own ruling and finding. And you are being asked, including by counsel, who did not listen or take part in the prosecution of the application, like my very good friend Mahat Somane, and who therefore they are regurgitating their very argument.
Unajua, mimi nimeshangaa. Ruling imekuwa delivered, then they are making another application.
Sorry, Amolo, please, you lost me at Mahat Somani.
You are being asked by my colleague Mahat Somane, who did not participate in the main application prosecution, and who comes to regurgitate the very arguments his colleagues made, very ably made by Professor Muigai, who he now appears to want to better and repeat the arguments. Your Ladyship, the very act you are being asked to do has no foundation in law. And that is why, Your Ladyship, none of the 7 or so senior colleagues who address you cited any law anywhere. Not the Constitution, not the rules made thereunder, nothing, because none exists. They have used various words interchangeably, asking you to suspend the decision, asking you to hold it in abeyance, asking you for temporary stay. My very good friend and colleague, Murugara, has even used a new term, secondary jurisdiction. All these are not known to law at this stage. Your Ladyship, once the respondents are aggrieved as they say they are, they only have two options: to appeal, which they have said they will, with the option of seeking a stay of that decision on appeal, or to seek a review of your decision. There is no other avenue available to them. They are free to move to the Court of Appeal, and we are free to go there and defend your decision. Leadership, with respect, we will not, for our part, go back to start answering the very issues that were raised and which we responded to, and this court has made a decision. I decline the invitation by Mr. Mahat Somani, who wants to persuade you that he understands budget making more than all three current serving members of parliament who participate in it routinely, because we had already addressed it. Your Ladyship, the decisions you are being invited to look at by my learned friend Issa Mansour have no relevance. And Mr. Issa Mansour, as well as Honorable Murugara, know that I'm actually in that matter. And I'm actually leading the lawyers in that matter. That is a matter that related to existing legislation that had been in place. And there were about 29 pieces of legislation. And they also know that given that unique nature, it was not new legislation. This is legislation that was in existence. The Court of Appeal merely stayed. It is still pending. We are going to argue it properly. But the Court of Appeal stayed the suspension. In this case, Your Ladyship, what was then the finance bill was nipped in the bud by the orders you issued on 29th of June before it became law on 1st of July. In those circumstances, Your Ladyship, that act did not and has not come to take effect. Where the act has not come to take effect, the invitation for stay, Your Ladyship, is then one which is equivalent to one brought before your brother, Justice Kanyi Kimondo, and two colleagues less than 7 days ago. And that was in E080 and E084 of 2023. 080 and 084 of 2023. When they found that the position of CASs were unconstitutional. And when invited to state their own finding, they stated that there was nothing to stay, just like in this case. That in fact, to issue a stay would now be to actually validate those positions. Your Ladyship, to issue a stay of your decision would actually be to activate an act that has not been activated. Why my learned colleagues would suppose that this court would act in vain, give a ruling, and then give a second ruling negating the first one beats me. Your Ladyship,
Could you
for
repeat that?
all why my colleagues would suppose that the court would act in vain by hearing an application for 8 hours, giving a considered ruling, extending the conservatory orders, and then immediately negate that very ruling by activating the act beats me. Your Ladyship, I thought by now my learned colleagues were done with scaremongering, but they have now brought in new players with new words, forgetting, Your Ladyship, that it is now 12 days since you stayed the Finance Bill 2023. 12 days. Government has not shut down. My learned colleague, Honorable Murugara, who speaks for the National Assembly right now from the Speaker's office, as I can see, and who then chooses to speak even on behalf of the judiciary, knows that government has not shut down. For the very same reason as we submitted, that there are mechanisms for continuation of the Finance Act 2022, and that is what is continuing. Your Ladyship,
Mechanisms?
for continuity of the Finance Act 2022. And that is why, as we speak, income tax is being paid. As we speak, people are paying import duty. As we speak, everything else is going on except the new taxes and levies. Your Ladyship, it is my humble plea that you render yourself as you have on this matter, so that my learned friends can make haste and move the Court of Appeal where we shall meet, and to give directions on many other matters that are pending without being detained to rule on the same matters twice. I beg Your Ladyship that you dismiss these misplaced applications as by law provided. That's all, Your Ladyship.
Thank you. Tata?
Yes, my lady. Yeah, my name is Okio Mpepoko, which is the first petitioner. I'm acting in person. I fully echo the submissions of Senior Counsel Otienda Molo. And I'll just reinforce them by saying that the claims that sections of the Finance Bill 2022 were repealed or amended by the Finance Act 2023 are not true, because the Finance Act 2023 has not come into effect. That will only happen in the event you suspend your orders, my lady. It will bring that act into effect, and then whatever they're complaining of, or whatever they're relying upon will happen. So far, the Finance Act 2022 is intact. And given that the Finance Act simply gives measures for raising revenue, the government will continue raising revenue using those measures that have been given in the Finance Act 2022. So no prejudice will be suffered by the government or by anybody in this country. Number two, my lady, the respondents are raising an appeal before the trial court. This court cannot sit on appeal in its own decisions. The only way open for them is to go to the Court of Appeal and make their case. I also want to reinforce the fact that the laws relied upon where the court suspended its finding of unconstitutionality are distinguishable from this case. In the 23 laws where the Senate challenged the enactment, those were laws that were already in force when the Senate moved the court. Similarly, when I challenged the CAS position before Justice Murima,
Just a
and he
minute.
agreed with me that
Tell me about the 29 laws.
the 23 laws that were found to be unconstitutional, then the finding of unconstitutionality was suspended for some period, were already in existence. And that's distinguishable from the case herein, where the Finance Act, as Land Council rightly pointed out, was nipped in the bud before it could get into effect. So the status quo prevails, and the government will continue operating the way it is. Number two, I also wanted to refer to a situation whereby, I don't have the case number, this case of the chief administrative secretaries, which I litigated before Justice Mureba, 2021-2022. When the judge found the positions to be unconstitutional, the officers were already in office, and he suspended it to allow the government to regulate or to comply with the orders he had given, because the officers were already in office and he didn't want to disrupt their operations. But in this particular case, the law is not in force. There's nothing to stay, because the stay will bring this law into force. You will not retain the status quo. If you suspend the orders, they will not maintain the status quo. They will change the status quo whereby the Finance Act 2023 will become operational, and we shall have acted in vain. So, my lady, if you look at the impact of suspending your orders, nothing will be left for us to litigate, and you will have acted in vain. The best we should do is to fast track this matter. This is a matter I'm sure we can dispose of in 7 days before the bench to be empaneled, and the parties should be given directions to move with speed so that you can have an expedited hearing that will determine these issues, because we are just dealing with matters of law, largely. So I pray that the application to stay your orders be denied, and the matter be given an early mention date before the bench,
Yes.
so that we can have an expeditious hearing and an early determination. That's all, my lady.
Please, your ladyship.
Your ladyship.
Please, your ladyship. Manzo,
Just a minute.
for the
Just a minute. Senator Mtata, you're done? I got disconnected a bit.
Yes,
Okay,
yes, my lady. I said that was all. Unless you have a question for me, I'm done.
okay.
And I requested that you don't allow the application to suspend. And my lady, it's also, maybe I just finish it off. My lady, it's also clear that they have not brought out anything new
I can't hear you. I can't hear you. I can't hear you.
that would require the setting aside of the orders. They have not, they're just litigating what we argued over last time, and trying to fault the court for having arrived where it arrived. To me, the court has acted judiciously, and it cannot be faulted. It has acted to preserve the substratum of the case, so that it can interrogate the issues and make those determinations. It's a very, very important matter in terms of devolution in this country, in terms of equity, in terms of taxation, in terms of the Bill of Rights. So the end cannot be used to justify the means. The government has got the power to tax, but it should do so within the confines of the law. It cannot act outside the law and say, therefore it must benefit to breaking the law. It should not be allowed to break the law, then benefit from it. But what's important is that I've not demonstrated that the government will shut down. The government continues operating as it has been operating. And 14 days, over more than 10 days since you gave the injunction. That's all, my lady.
May I please election?
Yes,
My name is Manzo for the 7th petitioner.
just a minute. Unmute yourself, please.
Yes, you are unmuted now.
Yes.
I just want to mention one matter under Article 222 of the
Yes.
Constitution and 223. Now that the Appropriation Act has been mentioned, my colleagues, Honorable Murugara and the rest are aware that the Appropriation Act results out of Committee of Supply, and every single item proposed in the budget and to be funded is passed one by one in the Appropriation Act, and it has got nothing to do with the Finance Act. It's a totally different act of Parliament.
Just
different
say
from
that
the
again.
Finance.
Every item is done what?
Every item is catered for in the Committee of Supply,
Yes.
and it is passed one by one by the House for all the projects and government undertakings for the new financial year. And then that has got nothing to do with the Finance Act. The Finance Act is foundationally supposed to be dealing with new taxes only. And the safety net is in Article 222 and 223, so that whatever has not been catered for, or in the event the finance bill or act has not passed, then the government still is allowed by the Constitution to carry on with its activities and to draw from the consolidated fund. So there's nothing which is not taken care of by the law, by the Constitution and the existing laws. Therefore, the Appropriation Act does not apply in the circumstances we are dealing with of the Finance Act. It is intact, and all the activities passed in it will be taken care of under Article 222 in the event there is no finance bill at all. But luckily, we have the Finance Bill 2022 still in force. Thank you, Your Lordship.
Lady, if
Yes.
please. My name is
This is
Blair
who?
Angimo. My name is Blair Angimo.
Can we go systematically? We need petitioner number 2, petitioner 2.
Okay, I'm guided, my lady.
With your kind permission, Your Ladyship,
Yes.
it's Eliud Matindi here. I am the second petitioner litigant in person.
Yes.
I associate myself with what has been said so far by and on behalf of my co-petitioners. And I request that you refuse to suspend the conservatory orders that you have issued with regards to the Finance Act 2023. The ex parte orders that were issued on the 30th of June 2023 stopped the act from commencing on the 1st of July 2023. On that basis, the changes that had been introduced into law by the Finance Act of 2022 continue having the force of law because they have not been repealed by the Finance Act 2023. In addition, Your Ladyship, your ruling was based on the inter-parties hearing that took place on the 5th of July. Where all your ruling today.
Please say that again.
Your ruling today allowing.
Mr. Matindi, you need to repeat. I had gone off again.
Thank you, Your Ladyship. I was saying.
Yes.
That your ruling today was given after you had considered the arguments and submissions of all the parties in this matter at the hearing on the 5th of July. In your summary, you set out the reasons why you believe that the conservatory orders meet the requirements of the law, including preserving the gravamen of the main petition, including balancing the interests of the public in terms of being charged taxes that may turn out to be unconstitutional, balanced with the need for the state to raise the required revenue. It is a matter of record, Your Ladyship, that the Finance Act is in 2023 is intended to yield an extra 211 billion Kenya shillings, I believe, over and above what was raised by the Finance Act 2022. So those taxes that were raised in 2022 or under 2022 will continue to be raised. The only ones that will not be raised are the additional ones provided for by the Finance Act 2023. Your Ladyship, as I said at the hearing on the 5th of July, the Constitution cannot subvert itself. The Constitution empowers you to use your discretion upon hearing all the parties and applying the law to the facts as proven. The ruling that you delivered this morning or this afternoon, I beg your pardon, indicated that you did the balancing that was required of you. If the respondents are unhappy, as evidently they are.
Please repeat the ruling.
The ruling that you delivered this afternoon.
Yes.
Was after you considered and hearing all the parties and balancing the various interests that needed to be balanced. Respondents, being aggrieved by your ruling, are at liberty to approach the Court of Appeal. And we will meet them there. However, suspending the order, Your Ladyship, will activate the Finance Act 2023, which means the dangers which were identified will crystallize. The effect of that is that should the Court of Appeal decline to review or to reverse your finding, Kenyans will have been taxed outside the provisions of the law, not least because the substantive case has not been decided. Your Ladyship, I am reminded of the Court of Appeal decision in civil application E126 of 2023, which is the application concerning.
Would you repeat that?
I am reminded of the decision of the Court of Appeal in civil application number E126 of 2023, whereby
yes,
the court had been asked to suspend conservatory orders in the then ongoing case of the chief administrative secretaries. The court declined because it was of the view that the conservatory orders were needed for good order and to give the High Court the space and the chance to hear all parties. Equally, Your Ladyship, I am reminded of the decision of the Court of Appeal in Attorney General and another versus Coalition for Reform and Democracy and 7 others, 2015 EKLR, where the court was considering an application for stay pending the hearing and determination of a matter.
Just a minute, Mr. Matindi.
Thank you.
Unmute yourself and proceed.
Upon hearing the parties in that matter, Your Ladyship,
yes,
the court said that, and I'm quoting here, Your Ladyship, if the court has suspended an act pending the hearing and determination of its constitutionality, a strong case has got to be made to lift the conservatory order. Those seeking the order to be lifted, in this case the state, they have to demonstrate that the suspension has occasioned a lacuna in operation or governance structure, which, if left unfilled, even if for a short while, is likely to cause grave consequences to the general populace. Your Ladyship, as we have said, the tax-raising measures in Finance Act 2022 continue being in operation. The Appropriation Act 2023 was published on the 26th of June, 2023. It came into operation on the 1st of July, 2023. So insofar as the Appropriation Act is concerned, it is neither here nor there because that act is already in operation. As to the prejudice which was identified by your ladyship that would arise if the orders were not granted, your ladyship reversing yourself on that would take us back to the ex parte consideration on the 26th, or was it on the 29th, when you consider the matter ex parte. We go back to square one. You considered the issue, you weighed what needs to be weighed, you came to a decision, and it is my prayer that you stick by your decision. It is my considered view that that was the correct decision. However, those who do not agree with that decision are obviously free to approach the Court of Appeal, and the Court of Appeal will make a decision that they believe is appropriate. Those are my remarks, your ladyship.
My lady, I am Benson Otieno.
Thank you, Mr. Matindi. Yes, Otieno?
I am Benson Otieno,
Yes.
the fourth petitioner and the litigant in person. I share everything that my co-petitioners have said, and I have only 3 points to add.
And may I request you not to repeat what has been stated by your co-petitioners?
I share everything that has been stated by my co-petitioners, and I have only 3 points to add.
Yes, Mr. Otieno, my request is that you do not repeat what has already been submitted on. Please unmute yourself.
Thank you.
Mr.
I will not repeat.
Yeah, in the interest of time, Mr. Otieno.
Yeah, I will be very brief.
Yes.
To begin with, I appreciate the position you have taken and believe that you have given a very fair ruling. The respondents, though dissatisfied, have not alluded to even a single ground or reason as to why they believe that you have erred in law. So technically, they are simply unhappy with the decision because of what they have called impact or the effect of the suspension. The chorus of impact and effect of the suspension of the act is not new. It is what this court dealt with on the 5th day of July for over 6 hours. The only new thing is that we have had a new counsel who has canvassed that issue on behalf of those who did it on the 5th day of July. My second point is that you have not made any substantive decision that is capable of being challenged on appeal. So the threat of appeal here should not scare the mind of this court. There is no substantive decision. Your orders and directions are merely procedural, and they are designed to prepare a platform for the parties to litigate the petition. That is what you have done. So the threat of appeal, they should carry on with it and move to the Court of Appeal. My third point, and the last one. The respondents have cited petition number 253 and 238 of 2018, which were consolidated. And
Petition number?
Petition number 253 and 238 of 2018, which were consolidated, and they concerned the suspension of an act of parliament. What the respondents have not said is that those petitions were not as unique as ours, in the sense that our petition sought to challenge, in fact, to bar Parliament from debating clauses or provisions in a bill that, from the face of it, threatened the Constitution with violation and threatened violation of the Bill of Rights. That is the petition, which clearly the respondents have not appreciated until now. Another thing they have not appreciated is that at least each of the petitioners in this case submitted memorandum to the Finance Committee. And the issues that we are litigating here are issues that we presented to the committee and were ignored. It is therefore very unfair for the respondents to what I would call feign ignorance and start pleading the doctrine of necessity. I would repeat, like I said on the 5th day of July, that necessity is a very unfortunate doctrine. And it is the common color in the flags of every failed state, which we would not want Kenya to join. So we ask this court to clear its mind and forget about the impact, the effect of the Finance Act. I'm limiting myself to things which have not been said. And finally, I just want to make a quick rejoinder to a proposition by the Council for the Parliament, National Assembly, that this court, that the executive is the first arm of the government, there's a second arm of government, there's a third arm. That is not the position in our Constitution. The Constitution provides for 3 arms of government, which are all independent. And there is no hierarchy as to which one is the first, which one is the second. So this court is in the same capacity as an executive because of its independence. So that one should not threaten this court. I thank you, my lady.
My lady, my name is Blair Ngimo, and
Could you please wait until I allow you to address the court? I'm still trying to finish writing what your co-petitioner said. Thank you, Mr. Otieno. Yes, Angima?
My lady, my name is Blair Ngimo Igoro, and a litigant in person. I want to be very brief because I also am aware that you have been writing the whole day, and in the interest of time, I want to point this honorable court to 2 authorities. The first authority being the Judicial Service Commission versus the Speaker of the National Assembly, and another, it's a 2013 EKLR case, in which it was stated that conservatory orders are remedies provided for under the Constitution of Kenya 2010, which is the supreme law of the land. They are orders which are meant to keep the subject matter of the dispute in situ. Basically, what this case is stating aligns to our petition that the Finance Act 2023 is yet to come in play. And as such, I commend the court on the trajectory that it has taken in suspending that act, because it is yet to come in play, and matters of constitutionality ought to be listened to. Secondly, my lady, I want to point you to the second authority, which is Gatiru Peter Munya versus Dixon Mwendwa Kidinji and two others, 2014 EKLR, paragraph 86, and the court stated conservatory orders consequently should be issued when a case is presented and the merits of that case are practical. And secondly, from that case, the court stated that bearing in mind public interest, the constitutional values, and the proportionate magnitude to the relevant causes, what I submit to us today before this honorable court, my lady, is that we have presented a prima facie case in which the Finance Act is clearly in violation of the Constitution. And as such, I commend this court for applying its own wisdom, and it should not be afraid of what other arms of government are here to state. As earlier alluded by my co-petitioners, and to be more specific, Mr. Benson, is that judiciary is an independent arm of government, and in the doctrine of separation of powers, it sits on the same level. If I may say, it's a horizontal separation of powers in which there is no arm of government which is greater or stronger or above any arm of government which is listed in the Constitution of Kenya, that provides for separation of powers. With
no arm of government is what?
I submit to the court that in separation of powers, every arm of government is equal and independent. There is no arm of government which is greater than the other. I therefore want to rest, and I humbly submit, and I want to thank this honorable court for doing what the public deemed commendable. Thank you, my lady. I rest.
Thank you very much. Mr. Kirao Kimani, any rejoinder on behalf of the...
Yes, thank you, Ladyship. With tremendous respect to the petitioners, their addresses arise from a major misconception as to what jurisdiction I've invited you to exercise. They have proceeded as if you were being asked to overturn your own decision. Now, the case of Madhu Paper versus Carr, which dates back to 1985, makes three fundamental points. Which is what constitutes the new jurisdiction. The first one is that there is nothing inconsistent in the court of first instance having exercised its powers in a particular way, in that case, through refusal of an injunction, for purposes of allowing a level playing field, issuing a contrary order, in that case, an injunction, which it had just refused. And
Sorry, say that again?
There's nothing to stop the court of first instance issuing, pending, accessing the Court of Appeal, an order which it had just refused. In that case, it was an injunction. The converse is, in my humble submission, true, that even where the court has been persuaded to issue an order, it retains the jurisdiction to suspend its own order, again to allow access to the Court of Appeal with the status quo ante that preceded the making of the order. The second point that that case made clear is that the Court of Appeal prefers that the High Court be moved in the first instance. So that it can see what the judge made of the issue. The third point is that the Court of Appeal will be The third point is that the Court of Appeal will be exercising its own discretion.
Sorry, I went off again.
Sorry, I was saying the third point the case makes is that the Court of Appeal will be exercising its own concurrent decision.
Exercising its what?
Its own concurrent decision. Its own concurrent jurisdiction, I beg your pardon.
You're saying the Court of Appeal will be exercising its own concurrent to what?
Yes, concurrent jurisdiction. Both courts have jurisdiction. That's the point.
Yes.
The High Court has jurisdiction. The Court of Appeal has jurisdiction. So that all the arguments suggesting that you are being asked to sit on appeal are, with tremendous respect, without foundation. It has been said to you that the respondents are raising some of the points they raised on the 5th of July. With respect, there is nothing wrong with that. Even an appeal is by way of a rehearing. The same arguments will be made before the Court of Appeal, which may reach a different conclusion from your ladyship, or may reach the same conclusion. We are not there.
Yes.
It has been suggested that the two petitions, the consolidated petitions, the decision in the consolidated petitions, 284 of 2019 and 353 of 2019, cited by Mr. Issa.
Numbers?
284 of 2019 and 353 of 2019, the position in that decision is different because the contest there concerned existing laws. With respect, there is no basis for this argument. First, there's no hierarchy of laws. Once Parliament has enacted a law which has received assent, it is a law, and the fact that it is a day old, or in this case, as they say, and I'll return to that, it was nipped in the bud, doesn't make it any less an act of Parliament. The principle is what matters. Can the High Court suspend its order? In my humble submission, it can and should. Let me now come to the argument that this act had not become law.
I am thinking you are in your own world, I'm in my own world. You are saying your own things, I'm saying my own things.
Please unmute yourself, Mr. Kimani.
Thank you. The Finance Act received presidential assent on the 26th of June. All that was left was a commencement, and it is to be noted that there were certain provisions which were to commence later than others. The applicants contend that the Finance Act 2022 continues on account of the order made on 30th June. No one has pointed your ladyship to any saving provision or transitional provision that supports this argument. No one, in fact, has demonstrated that the contention that Finance Act and related statutes are an annual occurrence the correct position is what the second petitioner, Mr. Matindi, referred you to in petition number 2 of 2015, which is that it is for the Court of Appeal to be allowed an opportunity to consider whether a case has been made out for the suspension of the order pending the appeal. The invitation to you is suspension for a limited period. And I think it's important that we put things in perspective. The petition was filed on the 31st of May, 2023. No conservatory orders were made until the 30th of June, a month later. And when we ask your ladyship to give us 7 days, move to the higher court, we are accused of undertaking preposterous ventures, of using multiple words, and the like. If we survive for 30 days without conservatory orders,
please unmute yourself.
We survived 30 days without conservatory orders. 7 days is not too much to ask for. It has been suggested that government continues to function 12 days later. This is a statement from the bar against sworn statement by no less than the first respondent, the Cabinet Secretary for the Treasury, as to the consequences.
Sworn statements by?
The first respondent, the Cabinet Secretary for the Treasury, National Treasury.
Yes.
As to the consequences of the annual budget making process, of which the Finance Act is a key plank, being suspended. Quite clearly, as at the time the order was made, the 30th of June, things such as wages had been processed. It is wrong to suggest that the court is in any way being intimidated through scaremongering. Your Ladyship, if you'd be so kind as to allow Mahat to manage just a few minutes to respond to one or two issues.
Had been processed?
Had been processed, and
yes,
and raising the concerns which are set out in the Cabinet Secretary's affidavit is not scaremongering. We will see the consequences in days to come.
Sorry, I didn't get the last thing you said. Like I keep saying, my connection keeps going on and off.
Thank you.
The
I
last
was
thing
saying, Your Ladyship,
yes,
that the wages had clearly been, things like wages had been processed by the time the order was made on 30th of June, and the serious repercussions going forward are well articulated in the first respondent's replying affidavit. We're not asking Your Ladyship to second guess yourself. We are asking you to allow us to access a higher court without a millstone around our necks. And with your permission, I'd just invite Mr. Mahat Somane to say one or two things in reply. I'm very much obliged.
Thank you.
Your Ladyship, just for the record, Your Ladyship, may it go
Yes.
on record that my client, the first and the second respondents, are constitutional office holders. They will abide by the orders
Yes.
of this court and indeed any other court in the Republic.
Sorry?
They will abide by the orders of this court and indeed any other court in the Republic. They respect the solemn oath of office they took to respect any orders that this court and any other court may give. So the issue of the independence of the judiciary, the issue of intimidation that the petitioners are harping on is nor here nor there.
Independence of the judiciary and what?
Independence of the judiciary and intimidation that the petitioners are harping on is nor here nor there. Our client will abide by the orders given by your court, Lady Justice. That's the first point. The second point that we want to make, Your Ladyship, I was involved in E080 of 2023, E080 of 2023, that is the CAS matter, the consolidated petition. And the reason why the court did not stay those orders when the prayer was made after the judgment had majorly to do with the fact that the court had given a negative order, a dismissal, which is a negative order. But Your Ladyship, if you look at the orders of this court today, the orders that you have given in the notice of motion by Mr. Omtata, they vary from 1 to 6 orders. And Your Ladyship, those are positive orders mandating my client to undertake certain actions, prohibiting my client not to undertake certain actions, mandating certain institutions not to undertake certain actions. So the accommodation we are asking for, Your Ladyship, is not a review of your order, is an abeyance, a temporary stay for 7 days to allow my client to be able to, number one, move to the Court of Appeal, but importantly, to be able to adjust his situation or circumstance. You will appreciate, Your Ladyship, that the Finance Act had been negotiated and public participation has been going on for a period of time. Certain institutions, based on the bill, made adjustments to their systems, to their processes. If the court has now stayed those provisions, Your Ladyship, my clients needs that time, not only to move to the court, but to be able to adjust their situation. And how are they able to adjust their situation? Number one, if it is the court order that the additional revenue is not collected, then that means that my client has to look at the expenditure and the appropriation, because the revenue will not be matched with the expenditure now. Number two, if you look at certain provisions of the Act, like Section 47, it mandated the KRA to undertake electronic invoicing. So certain institutions have to also—
Would you please repeat? Section what?
47 of the Finance Act. It mandated the Kenya Revenue Authority to undertake electronic invoicing of goods and services. So these institutions within those 7 days—
Mr. Samane, I'm struggling to keep up with you.
Yes, Your Ladyship. I will go slower.
Remember, we're not having a conversation. I'm listening and then writing. Eh?
Okay, Your Ladyship. I am very sorry.
Right.
I speak too fast generally, but I will try to.
So it mandates a KRA to do what?
It mandated the KRA
to
undertake electronic invoicing for goods and services. That's just a simple example. And Your Ladyship, that process had been ongoing for a period of time. Now that the court has given conservatory orders suspending the act, my clients need to engage these institutions with a view of transmitting this order, ensuring that we comply with this order, and even coming back to this court
has to engage these institutions
to transmit this order for compliance.
Yes.
And even come back to this court in the event there is any hardship in compliance. And the reason why we are asking for the 7 days is to just make sure that we don't have an avalanche of contempt proceedings against various officers and constitutional office holders before you, Your Ladyship. That's the second point. The third point I want to make, Your Ladyship, is a misrepresentation that has been harped on by the petitioners.
Was contempt proceedings against constitutional officers before me?
And before you, and even before you and this court, for non-compliance with those orders.
Yes.
The third point, Your Ladyship, I wanted to make,
yes,
is the representation that the Finance Act was nipped in the bud and did not come into effect. Just for purposes of clarity, the Act was ascended to on the 26th of June, 2023, by a Gazette Notice Supplement number 97 of 2023. So by the time the orders were being given, the Act was alive. And that is why, the proof of that is in the pudding. That is why Mr. Omtata had to amend his petition to include those provisions, various provisions of the Act. And in fact, if you look at the petition, he is very specific. If you look at prayer 2, and 3 and 4, he refers to those sections of the Act. So they are aware that the Act is alive, that the Act came on board, and we submit. Of course, the court has the power and the jurisdiction to declare any provision unconstitutional, but the Act came into force. Certain provisions will come into force before others, but the Act came into force through that Gazette Notice. And that is a very important point for the court in looking at whether to grant this abeyance. The last point I want to make, Your Ladyship, is the point that was made
my learned counsel, Mr. Manzo, as it relates to Article 222B of the Constitution.
Yes.
The Article 222B of the Constitution allows the government to do appropriation up to 50% in the estimates. Our submission is brief on this point. These are exceptional, and it is very clear circumstance which allows the government to do that. In the normal order of things, an appropriation act is passed, and even if you have to appropriate only 50%, my clients will not know what to prioritize. And that provision is an exceptional provision in the Constitution for emergency purposes and not in the ordinary course of appropriation. Lastly, Your Ladyship, you asked a question which no one has answered. And this question, in fact, it is magnified by the prayers that is sought in the petition.
Yes.
The prayer, the question you ask is, are there savings provisions within the Finance Act 2023? The related question is, what are the fallback mechanisms for my client? If there was a prayer in the petition, pending hearing and determination of this petition, that the court grants an order that the Finance Act 2022 shall apply for purposes of revenue mobilization, we will not be having this conversation. We are having this conversation and praying for these 7 days because the court cannot give such a prayer. It's not in the petition. Parties are bound by their pleadings. And my client is stuck because they don't know how to move. It is the most sensible prayer to this court.
My lady.
Yes.
With your kind permission.
Yes.
I object to the kind of submission Land Council is delivering. The petition, my lady.
Sorry?
Is arguing the petition.
Yes.
Right of to reply. He's arguing the petition. It's arguing matters of fact. Is delving into the merits of the petition. And yet at this stage, he's supposed to be urging his case for stay. And he should be arguing the law at this stage because he's replying. I don't see why he's going into the merits of the petition and not arguing matters of fact.
Your Ladyship, I'm not arguing matters of fact. I am raising the issues that have been raised in rejoinder because that was an issue that that counsel for the petition has raised
yes.
as relates to what is the fallback provision. That is a matter of law. I know it's a difficult thing for Mr. Omtata, but that is a matter of law. And our submission here is very brief. There is no fallback.
Mr. Somane?
Yes, Your Ladyship.
I'm not sure that last comment was necessary.
Yes, Your Ladyship. Your Ladyship, with your kind permission, our submission is there are no fallback provisions on the Act
yes.
as relates to what our client is supposed to do because of the orders that has been made. and that is not helped. The orders in the petition as well as the law does not say what are the fallback provisions. Those are our brief submissions, Your Ladyship, and that is why we pray for these 7 days to be able to undertake some of these issues that I have seen. With those brief rejoinder, Your Ladyship, thank you so much for your time and thank you for accommodating us. Thank you.
Mr. Somane, just a question, a quick question.
Yes, Your Ladyship.
So
Yes, Your
exactly what will happen in the 7 days?
Your Ladyship, within the 7 days, we have to
just a minute. And unmute yourself.
Your Ladyship,
Yes.
you have seen something that is practically before you now, and
Yes.
I will. You've seen that there's an application to cite EPRA, which is not a party here. There's the KRA is also a party. There are various entities within the Finance Act, okay, that are required to undertake certain things which they have already started. Within those 7 days, the Attorney General and the Minister for Finance have to go and, look at this court order, interpret this court order, and try to talk to those institutions on what needs to be done based on the order that the court has made. And Your Ladyship, if that is not done, we run the risk of 20 contempt applications against various government officials. And that is why we're saying within those 7 days, the Minister for Finance, who is a party here and who's filed a substantive affidavit, the Attorney General, will be able to advise these various entities because of the orders the court has made. I think it's a fair proposition to allow for that. Apart from the appeal to the Court of Appeal, which is a right of appeal, there's this other issue on the mechanism of enforcing the order of this court. And as I started, the instructions of our clients is they will abide with the order of this court, and they want to be given time to look at this order with a view of ensuring that they comply with this order. And that period allows them to do that, Your Ladyship. Thank you.
Yes,
Very well.
2 minutes. 2 minutes.
Yes.
Yes. In a very brief reply.
I will hold you to that, Honorable Murugara.
In a very brief reply.
Yes.
First, what jurisdiction are we asking you to exercise?
Yes.
A specific of jurisdiction. The first one, you have 2 types of jurisdiction.
Yes.
The first one you've dispensed with.
Yes.
Which is grant the conservatory orders. But you also have a second tier jurisdiction, which is to stay temporarily the orders you have granted. Case law has been cited, and I rely on it as far as injunctions and conservatory orders are concerned. As regards the Finance Act, this is an annual act of Parliament. That is why they are always sequentially named after the years. And those years flow from one year to the next one. As we speak, we do not have a Finance Act of 2022. And if you cite it, we would say repealed, because it is actually repealed by a fluxion of time. The correct position is that by the 30th of June every year, a new Finance Act has to be in place. And therefore, for any argument that we have the old Finance Act, that argument will not be valid. As regards the arms of government, there is no specific order into which they are stated or they are ranked or whichever way they are put across. But for purposes of this argument, we started with the executive because it collects revenue. We went to Parliament because it appropriates. that appropriation is even to the third arm of the government, the judiciary. So whichever way it is, that is the order we used to show that those three arms of government are adversely affected by the orders in force, and a temporary reprieve possibly gives us some time to reconsider our positions and also to move to the Court of Appeal, where we are persuaded that we would actually urge a vacation of the orders that have just been confirmed. As regards the terminology used for what we are seeking before you, whether temporary stay, whether abeyance or suspension, it amounts to the same thing. That we require some reprieve from the court for 7 days. First and foremost, to move to the Court of Appeal. And number two, to evaluate our positions. Then the next one is the Appropriations Act, which was mentioned to by Honorable Manzo. The process of budget making starts with the budget estimates. Then we got the budget statement itself.
Just a minute. On Appropriation Act?
Yeah, on Appropriations Act.
Yes.
I wish to clarify that the budget making process starts with the budget statement itself, the estimates themselves. They are followed by the budget statement. From the statement, we come up with the finance bill, which leads to the Appropriations Act, which really means exactly that, money being distributed and being spent by various arms of government. So the correct position is we have to collect the revenue, and that revenue must be consistent with the approved fiscal framework in the budget, the Finance Act, and in the Appropriations Act. The suspension orders, the suspension conservatory orders granted have one fundamental effect, which is to disturb the revenue collection, and most certainly will lead to inconsistency with the approved fiscal framework as contained in the Finance Act. The
inconsistency with what?
Inconsistency.
Yes.
With the approved fiscal framework, which is enunciated in the budget statement, the Finance Act, and the Appropriations Act. We also have the Division of Revenue Act, which flows again from the budget estimates, budget statement, Finance Act, and Appropriations Act. The Revenue Allocation Act. And finally, why do we require the 7 days?
Council.
As I finish now.
Why do we need the
Yes, in the closing.
From the budget statement?
Sorry.
It flows from the budget. You're
Budget
saying that the
statement
Division of Revenue Act
flows from the budget estimates,
Yes.
the budget statement,
Yes.
the Finance Act, and Appropriations Act.
Yes.
Yes. So as I say, the 7 days that we are seeking will certainly allow the government to align the fiscal framework vis-a-vis the act granted. And as we weigh in onto what orders the Court of Appeal is likely to grant to us.
With fiscal statement and what?
The
fiscal framework and?
The fiscal framework.
Yes.
Yeah, within by the government, as the government considered and ways.
Just a minute, Council.
Yes.
The 7 days will allow government to align the fiscal framework with what?
Vis-a-vis. Vis-a-vis.
Yes.
The budget statement, the Finance Act, the Appropriations Act, and the Revenue Allocation Act. Also in line with what orders are likely to emanate from the Court of Appeal. We therefore urge your leadership to exercise your unfettered discretion in this instance and exercise that second tier of jurisdiction to grant the 7 days temporary stay orders. Thank you very much.
Does anybody have anything which is very different from what has been submitted?
Malady, I know the application was by the main parties, but there was a correction I just wanted to make. When Senior Counsel Otende Amolo was submitting, he said that the case that is pending in the Court of Appeal arising from the judgment of the High Court in the civil appeal was different from what you have. Malady, the correct position is that the appeal was allowed, and those interim orders managed to safeguard the validity of the statutes until the Court of Appeal delivered itself. So that the orders of suspension granted by the High Court and extended by the Court of Appeal remained in force pending the hearing and determination of the appeal, and the appeal was allowed by the Court of Appeal. And Malady, in fact, as we speak right now, they're just pending proceedings in the Supreme Court on parts of the judgment that was delivered. But the Court of Appeal did allow the appeal in the Court of Appeal, and therefore reversed the decision by the High Court, declaring those statutes invalid. Other than that, we associate ourselves with the submissions by my learned seniors.
All right, let me give my ruling on this matter.
Mr. Tarus. Yeah, man.
Sawa.
Sema.
Nasemaje?
Tunaita mkutano hata sijui kama ni mkutano. Mkutano wewe unaandika tu.
General.
Watch Rosemary Waweru, Beatrice Kamoyo, Nyambura Mwangi, and Fatma Mohammed as they